The next case is 1171 Rodriguez versus SUNY Buffalo. Good morning again.
Good morning, Your Honors.
Yep, good morning.
Good morning, and may it please the court. I'm Michael Samazi, representing the petitioner Scotland Rodriguez in this matter. I'm going to jump to right of the few issues that I raised in my briefs, Your Honor. First, on the state university's failure to provide a credible process for petitioner and their determinations of responsibility. By a plain reading of the published text, the university's controlling student conduct code at Article 3.35 for stalking necessitates that an emotional damage be incurred through coercive acts or offenses which collectively instill a fear of physical injury or harm. This last component for instilling a fear of physical injury and harm is a required element of the charge, once again, on a plain reading of the state university's own published code. In more than an hour of testimony at the hearing, at which I was present as well as his representative, and many instances of intervention and follow-up questioning by the state hearing officers, at no point did the complainant testify that the petitioner intimidated her, attempted to control her, or instilled any fear of personal harm in any way. Admittedly, by both parties, they experienced a very uncomfortable and messy separation. This student conduct code, written and enforced by both the state university and the state university police, and mirroring the penal law in many sections, likely requires this element so as to not allow for government encroachment and drag state law enforcement. Yes,
as I understand it now, you're addressing the substantial evidence question, right? Basically, at this point.
Yes, Your Honor.
Okay. So there, the question is whether or not there's substantial evidence to establish the stalking accusation, and you would say that the fact finders had no ability to infer from the facts the conclusions that would meet stalking. So, are you saying in that regard that there's no evidence to meet stalking, or that there's insufficient evidence?
Your Honor, I would say that there are several elements to this crime, violation, and they facially did not meet the element, this particular element. And their case law in this matter is clear that they can't infer for the complainant or for the situation that it existed. At one point, I believe in the record, and I believe it might have been in the respondent's brief, that the complainant asked somebody to walk her to her car. And by that, it was essentially an inference that there was a fear. A stated element of it.
Mr. Shamasi, the complainant did testify about the emotional, psychological impacts that she perceived the incidents to have occurred. But if I understand your argument correctly, and I need to go back to my question, you're saying that there's insufficient evidence for the conclusion of stalking as opposed to no evidence of it.
Correct, Your Honor. Though they have circled around it, they haven't met all the elements of their own stated charge. Therefore, it's insufficient, and I don't believe that's curable. They had over an hour to elicit what they needed from the complainant. It's very similar to a criminal law charge, and very similar to the writing in the penal law on this. There's a reason it's included, and if it wasn't specifically stated, I don't believe the state has the right or authority to infer it on behalf of a complainant.
What about the complainant's testimony that the conduct of your client following her around? Doesn't sound like, at least orally here this morning, you're contesting that he did follow her around all over campus after being repeatedly, exhaustively asked not to do that by her. You're saying that it didn't put her in fear of physical harm, so that one element is lacking. But she did state that due to this, she was so concerned that she couldn't sleep. Wouldn't that be a physical manifestation of her fear of your client?
Well, we do contest that, Your Honor. In our brief, I believe we contested every element of that. One of these instances was a Pokemon Go reference where he was several city blocks away. Another one, he was running on campus, and then he was told by the university that he shouldn't run on campus. This had nothing to do with where she worked. The university placed him in a dorm that was above her building, and we have an email that was sent contemporaneously to all the appropriate authorities asking for replacement. And then they put it back on him saying, why would you move there? Well, that's the dorm they gave him, and he instantly requested a new location.
Right.
So
look, it's all about intent. I don't think you or your client dispute the facts of all these contacts where they came into close contact with each other. You don't dispute that all happened. It's his argument was, well, it just was an accident that I happened to be around her. I didn't intend to be there. And maybe if there were one incident, okay, but there's just a series of these incidents. And, particularly troublesome is is the parking on those Wednesday nights when he knows her work schedule. She gets out at 7 p.m. on a Wednesday and he parks directly, he backs right into front of her car in a parking lot where there's plenty of other places to park. That seems suspicious. Now, we don't know his intent, it's subjective, but we can infer from his behaviors, after being told many times, stay away from her. 2 Wednesdays in a row at 7 p.m., he just happens to be parking right there and then he comes out. It seems a little much, and if we defer to the finders of fact, I think there's enough evidence for them to conclude that it was not an accident. It was not unintentional.
Okay, Counselor, anything further?
Yes, Your Honor. In this case in particular, there was also an issue that we raised about the university's failure to provide all evidence under their control. And there were, unusually in this particular matter, it came out directly. The complainant herself stated on the record of the hearing that she had provided evidence to the state that was not disclosed to the petitioner. A witness for the petitioner, Mr. Solomon, had submitted materials to the state university police investigator that they did not provide through the investigative process and the state through to the petitioner. And the petitioner himself had provided emails that directly spoke to much of this intent issue that I had just been speaking of with Justice Lindsay, that once again was seemingly unknown to the people, even though one of the principal actors had received it by email herself. Now, once again, these are 3 separate instances. Yes, Your Honor.
Nancy, with respect to the arbitrary and capricious argument, which is what I understand you to be addressing now, we really have to look closely to the extent that these arguments have been preserved, correct?
Well, yes, Your Honor. These issues, some of them came up at the hearing themselves, and we presented the documentation. The question is, how can a reasonable decision be made if the hearing officers are not provided everything that's in the state control, even ostensibly coming from the individuals that are running the process? The director of the Judicial Affairs Office directly received one.
Are we talking about this email? Is that what you're talking about?
That was one of the 3 I mentioned, the email that was sent to the director of Judicial Affairs and the director of the Housing Authority on the day that my client was placed apparently close to the complainant's workplace in the building.
Was the email relied upon by the hearing officer?
That I don't know. It wasn't provided to the hearing officers. We had it in our papers.
Was it in the decision?
I believe they referenced it, interestingly, in the decision with the word allegedly, as I recall, as in stating that they weren't sure if it happened, even though the email clearly was there with all the appropriate markings showing that it was sent at the right time and place. They could have been easily ferreted out by either of those individuals or the university's expansive IT department.
Okay, anything else?
No, Your Honors, thank you.
Okay, Counselor?
Good morning again, Your Honors. With respect to the substantial evidence issue, I will begin by noting that the definition of stalking that was provided to this court is incomplete. Stalking is Title 9 covered offense, and it's not just conduct that causes a fear of physical harm. It encompasses conduct likely to intimidate, annoy, or alarm another person. You can find that on page 7 of what we submitted as Exhibit B to the Russell affirmation. Putting that aside, it sounds like my adversary is arguing that even if there was a physical harm element to satisfy it, we needed some sort of talismanic recitation. I was put in fear of physical harm. But of course, in substantial evidence cases, in virtually all evidentiary cases, an element can be proven inferentially. And to that effect, we noted that this conduct did cause a physical effect. To the extent my adversary says they contest that, I'm not even sure that's something they can contest. They can't contest that the complainant here lost sleep over it, because that wouldn't be something within their knowledge. And with respect to her feeling compelled to need to come out of work with somebody escorting her, that is something that the Court of Appeals has recognized is evidence of a fear of physical harm sufficient to prove criminal stalking. So I don't think there's any dispute that can inferentially cause somebody to infer fear of physical harm. So
Counsel, can I ask you this? Can I ask you just to get a sense for me of what's at stake here? He had a 1-year suspension, which was up last month. He's completed all his courses, correct?
That's correct, Your Honor.
Now that his suspension is up, he can get his degree.
No, Your Honor, we are holding the degree because he still has unfinished business before the university. It's akin to if you have an unpaid parking ticket or an overdue library book. Until you have finished all your business before the university, you don't get your diploma.
So what business does he have left?
An ongoing disciplinary determination.
All right, so once this is over with, all we're talking about is a notation, and I'm not minimizing the significance, but what we're really talking about is a notation on his transcript about this. He's going to get his degree, he's going to graduate, but he's going to have that notation. That's what we're fighting over here.
Even
wants
if he
to get rid of
loses.
Well, Your Honor, if he loses, we intend to reimpose the suspension for a period of time equal to what was lost as a result of the stay. We put that in a footnote in our brief.
So eventually
Oh,
he'll be able to get his degree.
Eventually, yeah, with the suspension, it's the inability to get a degree for a period of time.
Mhm. Okay, I think we understand.
And so if I can just briefly address the procedural arguments, there are these emails. I would direct you to pages 52 to 54 of the transcript where the complainant referred to an email. Rodriguez objected, and the hearing officers expressly told him, we are not going to look at emails that we don't have. And with respect to the email that he supposedly gave to the university police and the hearing officers didn't have, that's not a failure of the university to provide evidence that's within its control. That evidence was within Rodriguez's control. And on page 87 of this transcript, it is apparent the hearing officers say, we don't have those emails. It's at that point that Rodriguez would have the responsibility to say, well, those were submitted. I think these are very helpful to me, and I'm going to offer them up now. Can I do so? Had the hearing officers denied that request, perhaps we'd have a different case, but that wasn't even attempted. And therefore, he cannot rely on the absence of those materials from the record now to claim that there was some sort of reversible error.
Thank you.
Thank you.